Alright, looks like we're all here.
I'm pretty much the same player, so we don't need to go into too much detail. The purpose of the... Sorry, JD, you ready?
Yep.
Purpose of the appeal is for the appellants to bring their case to the commissioners, and our responsibility as commissioners to decide whether or not we're going to uphold the decision of the Planning and Zoning Commission, or to basically remand this back to the Planning and Zoning Commission to hear it again. And then if we were to uphold the decision, or if you're not satisfied, once you're done, then we'll issue a written statement, and potentially we'd go to district court for resolution there. And like I say, we recognize the cost and inconvenience of that route. We'd love to be able to save you that at the county level if we're able to, but we'll do our best, and appreciate you making the drive down to San Juan County and doing this. So we'll hear first from the appellants in half hour for presentation and questions, and then we'll give Marcia Haydenfeld with the Planning and Zoning Commission equal time, equal format, and then we'll give sPower equal time and the same format, and then we'll come back to the appellants for final word on that. So if you're ready to go, we'll have John David swear you in, and we'll go.
Anybody who will speak? Yep, sounds good. If you don't mind raising your right hand. Okay. You do solemnly swear that the evidence you shall give in this issue, pending between Northern Monticello Alliance and San Juan County Planning and Zoning, shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Dan, before you get started, and if this is part of the program, I guess we kind of are curious to know if you represent all of the property owners, so if you can kind of explain your role with the property owners.
My name is Dan Bingham. I'm the Managing Director of the Northern Monticello Alliance, and I represent all the property owners over there. We have one who recently informed me he's taken some other actions. That's yet unresolved, but I think where he stands right now, if I gave him a phone call, he would work with us. His only issue, as I understand, is, well, basically his issue is he needs action on it. He's up against it financially, and he just wants it done sooner than later.
So
I do represent all 17, myself and another 16 others.
Okay.
And in fact, we did that. That didn't come as a result of our desire to get money. We had a conversation early on with what is known as Wasatch Wind Intermountain, not to be confused with Wasatch Wind Inc. and Wasatch Wind Intermountain, where Christine McKell has made certain representations of. In the early discussion, she suggested that we have one voice, and so we made one voice. Maybe they wish they hadn't done that at this point. But first of all, thank you for letting us come and speak to you. We had literally just a couple of minutes. This is the first time we've actually been able to officially speak about this matter, say for a couple of minutes of some public comments in October 4th of 2012. It's been difficult. Not only have we not had any time to be heard, we have not even been able to disseminate our documents to planning and zoning members. We've learned in that process that we've emailed certain documents for dissemination to planning and zoning, and we understood from Marcia that they weren't disseminated. And at one point, I believe it was September 9th, Mike, we came in and we handed out some documentation to the board to the planning and zoning members in hard copies then. And before the meeting, she went around and collected all but one, telling them that they could not have that for whatever her reasons. It didn't seem very American to me, but time will tell. We're 17 taxpayers in the county. Nobody is corporate rich. We're here for different, but basically the same reasons. In my case, well, as owners, we've hunted, fished, kayak, camped, started getting barbecued, and worked within spitting distance of right here. We've looked forward to enjoying this part of God's world. Most of us have personal and family histories here. My mother, for example, spent years in her now historic home, the Moab Springs Ranch. My My grandmother, I grew up hearing stories about the Red family and that family over the years. Some are, maybe I'll share with you at some point. Some might not be too appropriate for today or from this podium. Imagine you're sitting at home. You knock at the door, and somebody says, "Hey, I like your home." You answer the door. What can I do for you? I like your home. As a matter of fact, I like it so much, I'm going to get an appraiser to come and offer you. He's going to appraise it, and then he's going to give you that price. And if you don't sell it to me for that price, it's basically worth nothing. You can pay thousands of dollars for your own appraisal. I encourage that. But we won't promise that we'll accept your certified appraisal unless it matches our appraisal, and we can direct your appraiser. That you don't want to sell makes no difference. Even if we negotiate a price, we can come back later after we get what we want, decide we only want to pay a fraction of the originally negotiated price that gave us the benefit of where we stand today. What you want and what others say that is contrary to our negotiation tactic makes no difference. We're big, we're corporate. That we are ignoring customary business practices, even for Wall Street, that there's absolutely no case law which supports our taking, doesn't matter. That we are not a government entity. This is the crazy part. We're not a government entity. Usually we let our government do stuff like that over the course of the history of this country. But a corporation with certainly publicly recorded and documented questionable acts of the past. That doesn't matter either. You don't really need to know who you are. In fact, we try to ensure that by having people we work sign NDAs, non-disclosure agreements. At one point, sPower's attorney called, which you will, falsely stated and now writes, one or more landowners knew about the potential for a wind farm before the land, the 80 acres that's in question, was purchased. This is absolutely, as we stated before, completely false. A phone or deposition of a phone call or deposition of Tracy Livingston, the CEO of Wasatch Wing Inc., will totally refute that kind of ugly. The 80-acre deal that we are talking about today was struck in 2006 when no buyer, except myself, or prospective buyer either worked in the wind energy business or in Mike's case, Mike Cole's case, lived in Utah. Didn't even live in Utah, let alone work for Wasatch Wind. And oh, by the way, back then, as we now understand it, sometime thereafter, it was way down on the totem pole. The wind wasn't really good for the technology that existed then. It's really hard to imagine that we're so prescient that we could foresee wind technology. I could care less today about wind technology. I think there's better ways to go, but that's where we are today. It's amazing that we take this tact. We're all up here comfortable, and we're attorneys, and Sruti did a great job, I think. A little nervous. She's here by herself. But it's amazing that the county and all of us, taxpayers with property, are made to hurry up and make these rush decisions and learn a whole new process and a whole new industry and expect to hit the mark. But we are expected. That's your job. That's Marcia's job and everybody's job. But they're the ones who took the risk. They're the businessmen. They're the ones that are going to give you a fraction of the money so they can make a lot more money. And for them to come here and assume and posture that somehow estoppel is wrong. I tell you what, I hope this goes to the district court so we can resolve this dispassionately with the facts that we have. The idea that the county at one point wrote a document that as recently as September, was sent to us as the guidelines for an appraisal process to handle this mitigation issue was ridiculous. I think that's been totally refuted. I think the county attorney on September 14th, he said the rules are the minutes of October 4, 2012. They're not about a piece of paper that the county, eager to want this for maybe all the right reasons, came up with a document whereby they dictated how this was going to go. And I think case law and other informed minds prevailed, fortunately. I'm going to turn over this to Mike here very quickly, but let me just say in closing, The county is affirmatively obliged to protect individual property rights by only approving a CUP if it is harmonious and safe. That is the government mandate, your mandate, to protect. It's the first thing any government does. Developers did not mitigate the inholding landowners, but in fact did exactly the opposite as you see today. This corporation made their own self-imposed conditions. You allowed them to. And then they admit they didn't live up, at least in our case. Talk about everybody else if you want, but we're here about the NMA. So far it's gotten all it's wanted, but has never paid the price the developer, as October 4 states, they've not paid any of that price. And at the same time, it takes credit while not being associated with it. Oh, that's not our deal, they'll tell you. But they take credit for a payment in the contract that they say they're now not beholden to. NMA members receive payment for not accessing or altering our properties for 2 years. It was a rental payment to stay off and not do what we had planned on doing in our property. Now they'll tell you, oh, you don't even have access down the middle of your property. You don't. Of course we don't. We agreed with you. We weren't going to do it. And now here we are working on, going on year 3 where all practical intents and purposes, we don't have it. Yeah, they paid us money. They agreed to pay us money. There's no offer of fair market value to date, because when we were talking about the last, and I've got the emails, when I talked to Sean, and I've always approached them, tried to find out who they were when Wasatch dropped the ball, just like we tried to process, what's going on here, tell us. Even when the county told Wasatch Wind to contact us, they didn't contact us. So here we are again, going begging, hey, we have a minute, can we talk to you? Bottom line is, they didn't offer fair market value because we asked for some basic, why am I going to spend thousands of dollars on appraisal if they won't give me the guarantee they'll use that and won't do it in a customary fashion? There's no technical mitigation, as Mike will spend most of the time speaking to. There is no insider information. You can look at a calendar and find that out. They'll say it and hope it kind of picks up and floats. And I think it served, talking to some of the county officials, some in this room, it served them well. But I personally take that as an assault. And I want to tell you, anything I've said about any relationships of family or whatever, I've never, as the managing director, I've never said that the Adams were corrupt. I've never said that. I've been around my former profession. I know a lot about the criminal statutes, and I can tell you that stuff just has a way of catching up to people. That's not what we're necessarily about today. I'd be cautious. I'd like to hear about it if it's there. My only recommendation in that case is what I made before with the county attorney president. Why didn't they just do disclosures? Binding disclosures, not Facebook permit announcement that, to me, knowing what we know today, don't make sense. And like I said, we all got to a point, October 4th, 2012, where you agreed to move on because on the table we'd agreed how this would be handled. They took the risk to hurry up this project in a very narrow window before 2016 hits. They took that risk. They should pay for that risk. Not me, not Marcia, not you. And, ignore what their attorneys, they came before here on that date and said that everybody in Monticello, if not the county, what is the average, as I recollect, 13% loss in their property values. When I do the numbers and try to figure it out, even if this is a better deal to get income from this outfit, what makes us, why would we put the burden on all those people with private properties that when they sell their property or they try to take out a loan against their property, they're encumbered because of the Stoll-Rivas law firm assessment, their assessment, the developer's assessment, their public acknowledgement of a 13% devaluation of property. I mean, these are issues they brought. If there's any time to pay, they got to pay now. Because when they're done and they put the ribbon on the box and walk away and those blades are spinning, you try to get them back in court. That's why the building permit exists. You've never used it. We've heard you in the last meeting say it, and it's on record. It's recorded. In 20 years, you never pulled the building permit. That's why you do it. It's time to grow up. If we're going to have grown-up projects, this grown up in Monticello. I'm not trying to be pedantic at all. What I'm saying is escape the risk you now face, because we are going to go to court.
Okay. I appreciate the comments Dan's made and that Kimberly made earlier. Certainly we recognize the same issues that occurred in terms of the issues with timing of substantial work being done and all that. But We're going to try to address something different in terms of the mitigation that's actually happened or not happened here. And Dan, do you want to try to go through that? And most of my comments here in this PowerPoint are going to come from the November 5th documentation over there on the chair.
You want to get a position to see this guy?
But let me just say before I start, because Dan mentioned this, I worked for Wasatch Wind for a while. I worked on projects in Ontario, Canada. I can say under oath. Yes.
I have a question. If we're going beyond this hearing and you're saying that we're going to court, do we need to be here?
I think that was an emotional response at this point. We're looking for solutions.
We
And
want,
clearly,
if you
we
got
can't
better
go to court
solution,
till
we'd
after
like
this
to.
hearing's through. Because what we're going to court is against the process in the county, right? So the county has to finish their process, would be my understanding. But yes, I think this hearing's important. We've never been heard before. Been able to make a couple of public comments at the end, 2 minutes, on a couple of different meetings, but never an actual presentation. So we'd like to at least have that ability to do that, get two sides heard, because there's been a lot of misinformation. Dan mentioned this one. There's some concept that I had inside information or knew about this project before I can state under oath that I had no idea there was a wind project being proposed in Monticello
Okay.
at the
I'd
time
like
of the
to
purchase of this land.
ask Kendall.
Yeah, just to clarify, so the district court won't hear either case that you're hearing today until they've exhausted the local, the administrative hearing process, and this is kind of the final step in that. So,
Okay.
so yeah, we do need to have it.
Okay, and so I just wanted to say, as I've been sworn in, that I or nobody else in this group knew about the wind project before we purchased this land. I was like the last person, myself and a colleague that I knew, Tom Lynn, to buy this land when my friend Dan Bingo, I've known since high school, said, look, I've been trying to buy this land for the last months. Some other FBI agents fell out. Are you interested in doing this? And my family's trust said, well, we'll pick up, 2 lots, 2 5-acre lots, a 10-acre block. And then Tom Lynn, who loves this area as well, heard about it and wanted to do it. But neither of us had any idea. And there was, of course, no insider information, no thought of extortion. And Tracy Livingston will be glad to testify to that same. Or you can give him a call. I have his number. He's the founder and CEO of Wasatch Wind, Inc. There is a distinction because Wasatch Wind Intermountain was another company that was sold to Map Royalties, who was the developer, who made the petitions under the CUP, and then that was later sold to sPower, although it sounds like sPower had a purchase right even before we were approached about these properties. It sounds like they had a purchase option to buy all the way back to Redco in the beginnings of sPower. You can ask them about that. We can't. They won't answer. But it sounds like that they had a financial interest in this project going back even before we heard about it. So the first time we heard about this project was July 3rd. We told that it was going to go forward. On July 5th there was a meeting, but we were not told there was going to be a meeting. They purposely did not notify all the landowners, even though the Conditional Use Permit specifically said that it would impact the neighboring parcels in their intended use. They said that in their CUP discussion. So we were kind of blindsided about this. We were told to form a group, so we formed this group called the Northern Monticello Alliance to try to negotiate with them. So I wanted to do a few issues. Dan, if you could progress that there. This is the ALTA survey from September 25th, 2015, prepared by ECI for sPower Latigo Wind Project. This data shows the actual locations, or the latest. This is an actual survey of where the turbines are located. These properties, they call them the in-holding, they call them the donut holes, we call them the NMA, are that block of 80 parcels that you see numbered there in the middle. These turbine locations have changed significantly since the original data was submitted for the CUP application. These are the changes that's occurred, prepared by a GIS expert. If you look at the red dots, that was the original turbine locations. The green dots is what they're showing in their September 25th, which is during construction, so that's got to be the latest ALTA survey. You can see the nearest turbines on the north and on the west are almost half the distance they were. And of the 9, there's 12 turbines within 1,000 yards of our property. Of these 9 closest turbines, 7 have been moved closer, none have been moved further away. Setback distance is the biggest impact on noise. And the closest turbine in the north was 1,207, now it's 715. On the west, 1835, now 879. And so instead of mitigating noise for our property by moving the turbines further away, they actually move them closer. So no mitigation in that respect. Next. The other issue is maybe you can pick out a turbine or blade selection. They claim they've done that. The Latigo's noise consultant said the worst case potential turbine was 108 decibels. The one they selected, according to the records, well, let's just put it in context. 110 decibels is equivalent to a gas chainsaw or a siren. A GE turbine selected is 107.5, which is 108 when you round it, right? There was no turbine louder than the GE model they selected. Furthermore, GE offers a low noise blade option on their specific turbine that would have brought it down to 105 decibels. There's an option they could have selected, costs more. They didn't select it. They did not mitigate. So the turbine they talked about, the Siemens, was 105 decibels. That was the one they talked about in earlier presentations. So, and there is no, I have in the documents on November 5th, I listed all the suitable turbines and their noise limits. There are none that are louder than the GE one they selected. So they did not select a low noise blade or a relatively quieter turbine. Next. The other issue is noise standard. Their consultant recommended a Massachusetts noise standard, which is 37 decibels for residential and 42 for sparsely populated areas. There is no standard for vacant land because vacant land will never always be vacant. That's ridiculous. And so if you apply the Massachusetts study that they quoted, the standard for our properties would be 42 decibels. Now, Oregon has one of the best standards in the western United States, very well known, very well researched. It's attached to one of the attachments. Their statute says you cannot increase noise by 10 decibels, by more than 10. And they use 26 as a baseline. Our area is the quietest as it can be, so 26 would be the baseline. That would indicate 36 decibels would be the applicable standard. The Planning Commission did no research on standards. I saw no evidence that they looked at different standards from different areas and said, look, here's a list, here's what's happened in this state, in this state, in this state, here's what we ought to do. They relied solely on what was presented to them by a paid consultant who was paid by the developer, Latigo, to present a study. Every square foot of the properties in this 80-acre exceed 36, 37, and 42 decibels. In fact, the standard they made up of noise damage at 55 decibels still covers 17 of the 80 acres of the eminent parcels. And because it's a logarithmic deal, 55 is 100 times bigger than a 35, 36 standard that it should be. So the result is none of the parcels are within the decimal letters that a standard noise study should have been, found, and it's even above the standard they made up. Go ahead.
Wait, was that light today?
Yeah, light mitigation. Wasatch Wind Inc., the original developer, always planned on installing radar-controlled dark sky lighting called the OCAS system. Tracy Livingston has told me that directly just yesterday. And if you depose him or give him a call, he'll tell you that. The wind farms never put hazard lights on every turbine. sPower said, well, we negotiated the FFA to only put hazard lights around the perimeter. Every wind farm does that. Go by Spanish Fork. They're not in the middle of turbines. So really that's not mitigation because it's always what's done. If you want to do in order to get this thing passed, Wasatch Wind Inc. offered that as a self-imposed condition. And it was used to obtain good favor to receive the CUP. And that's the only way you could do max light mitigation as possible. Turning the lights down the substation is immaterial. I mean, it's on the ground. These things are seen for at least 3 miles. They flash every day. During the planning committee, one of the commissioners said, I thought the lights were going to be off. And I think Sean said, well, they are off. Or maybe it was Josh. They're off when they flash. They flash off when they flash on. And I'm like, no. They were told they were going to be off unless there's a plane in the area. With the OCAS system, the lights are always off unless the radar picks up a small plane in the vicinity, and then they flash on, and a verbal warning can be sent to the pilot. Otherwise, they're always off, so the residents here don't have to deal with these flashing lights. They're seen for at least 3 miles by definition.
And you might add that in the Wyoming project, they made, in the newspaper, they made OCAS representations on that project. For them to say now that they don't know anything about that, they negotiated with the FAA, simply not true.
Yeah, and of course, sPower knows that because sPower has been involved with this project for years as an option holder, and they also purchased the Wyoming project. Okay, Dan?
10 minutes, Michael.
Okay, Flickr, 7 of the 9 turbines are now closer. They're a little bit lower, but for as close as we are, that doesn't really matter. Flickr's exceeded at least 5 of the properties. Bottom line, Flickr standards have not been mitigated. Go ahead. Ice throw. This is a big issue because your CUP or your zoning requirements require that this cannot cause safety hazards to neighbors. The original CUP application, which in the left picture and left, this little screenshot of it, you have more detail in your package, you have the full study, shows where the ice throw range, the danger range, were by the blue circles. And they just missed our property, obviously by design. However, when they move these turbines closer, you see that the ice throw, these red circles, cover 2 of the parcels, and over 4,000 feet of the county road is now within danger of ice throw or turbine failure. And if you go on YouTube and look at exploding wind turbines, you can see how if the brakes ever fell on these wind blades overspin, they deform, they hit the tower, they blow up, and they fly all over the place. And there are multiple videos online, you can see that. Now, the important thing is self-imposed conditions. This was stipulated in the conditional use permit that if a developer made a condition, said they were going to do something, all future developers had to do that. That's a quote right there from the CUP. It was binding on future developers. Mitigation was not practical. And in the CUP application, Wasatch said it conflicts with the intended future use of these adjacent properties. That was in the July 5th meeting. As it was not practical, Latigo committed to negotiate a price to purchase every NMA parcel prior to significant construction activities. Next. The county delayed the CUP appeal that the MNA did so that we could negotiate. An agreement was signed in February to resolve the mitigation issue by Latigo purchasing all of the MNA properties if determined to proceed with the project. If you don't do it, you don't have to buy it. But if you go ahead with the project, before any significant construction, you have to buy it. Now, the landowners agreed to drop their appeal and were paid option money, as Dan said, essentially a rent payment for 2 months that was specifically not applicable to any purchase price or mitigation. It was compensation for tying the land up for 2 years. Latigo received the CUP but never completed the mitigation, and the approval that the approval was based on. And the Planning Commission said we did not verify any of the conditions of the CUP before issuing the building permit. Greg Adams stated that on record. Okay, the next one.
That is.
So when we negotiated this deal, and yes, we weren't as sophisticated as these guys. They said they're moving hastily because of federal incentives. We agreed to this we agreed to extend the option term before it expired. And at that time, we said, look, if you don't build it, fine. But if you do build it and don't buy the properties as you said you would, then yes, we'll have to pursue every chance we had. So sPower was on full notice before they even bought this project that was happening, unless Wasatch Wind did not, or MAP royalties did not disclose that. The self-imposed condition to purchase the MA parcels at the negotiated price never expired. Okay, it was offered to secure the CUP and the CUP property. Our option period went out, and of course these guys got extensions. We never figured that it would get an extension beyond the 18 months. Our period was 2 years. We figured with an 18-month extension, we would be covered to tie it up for 2 years. sPower is leveraging the county's lack of oversight and enforcement to renege on the deal that was there. And it was a fairly negotiated deal. There was no inside information. There was no extortion. They're just trying to walk away. It's fairly, from sPower's point of view, they're just trying to save money and basically kind of screw us out of what we'd already agreed to. San Juan has an obligation to enforce the zoning ordinances. There's a couple of quotes there. It can't be detrimental to the health and safety, which is ice throw and turbine explosion issue certainly does. It must make it harmonious with neighboring uses. 55 decibels is in no way harmonious. We don't pass any of the standards for mitigation. And self-imposed conditions are passed on to sell the property. If it's allowed us to go on this way, sPower got what they wanted, Latigo got what they wanted, we never got compensated. We're still stuck in the middle of the wind farm. And our only recourse is to try to seek damages. All right, now. Essentially saying that we fall into an eminent domain or into an appraisal process is like eminent domain without even the court protection of it. This is eminent domain for a private project. I worked on on a highway project where we used eminent domain, but we always paid way over the appraised value for these properties. We did hundreds of properties for a freeway system in San Jose, California that I worked on with Bechtel Engineering. So we don't even have these protections. The next one. I'm not going to go through too much here in time, but on the very first meeting, we were purposely not notified about the July meeting. At the October meeting, we were not allowed to present anything. We just got a couple of minutes at the end to add in some comments. We were not allowed to put documents we distributed to them were not distributed, even though the ones from the Latigo were. Again, on this 9th meeting, we were not allowed to talk. We were not allowed to provide rental information, and a list of questions that we handed out were pulled from the members. There were no disclosures that have been mentioned. There was no investigation of appropriate standards. Nothing's on the record about that. Our first grandma petition has never been responded to. It was appealed, but we never received any documents on it. And we were, but yet, sPower, we sent a letter to the county attorney, the county commissioners, and the planning administrator, and it was given to sPower the next day as conferred by Sean in a telephone conversation. And more importantly, they failed to verify with compliance with CUP conditions before issuing the building permit. And we've never tried to raise the price. We had a deal that was struck. They're basically walking away from it and leaving us in a hole, leaving the county in a hole, just because sPower wants to save some money from the previous deal. And with that, I'll take any
Let me
questions.
just make one comment to the commissioner's comment about mine. Look, we've made all kinds of attempts. Every attempt to resolve this has been initiated by us. Any representation, written or otherwise, maybe there's some kind of misunderstanding between Sean and myself. I don't think so. I've read what he's wrote. I see it. It's clear to me. I have emails that we've offered several options. And really the only thing, given that we're at this point in time, is that they just go by what the CUP does. I think that the lack of understanding, too, of what these planning and zoning can do with a building permit is because it's a lack of experience. They've not dealt with this before. The idea of the building permit is to have something there so that if you don't like something going forward, you can say, hey, we're pulling this. I guarantee you I won't cost them an extra cent. If they're threatened with a building permit pull, for example, not that you would do it, but it's reasonable, it happens all the time, all around the country, all the time, for issues just like this one. I can tell you, we're not going to go in there and ask for more money than we've already negotiated for, number one. Number two, it's not out of line with the comparable market analysis that we got from our real estate representatives. In our original market analysis, we had a property that was 1.54 acres and on the market for $54,000 at the same line just over here. They can make their points that they want, but what I want to do is say that, let you know, the bottom line to remember to sPower that's here and to you commissioners, is we're willing to talk to them. But for them to come to us, as I presented, as though we're sitting in a house, they knock on the door, you take this appraisal of ours or we're done, that's really no way to go, and it's not how it works. We're individuals. What if we don't want to sell the property and we still want to live there and they've got ice throw problems? I mean,
Okay. Is there any questions?
I've got a couple. So again, our job today is to look at how the Planning and Zoning Commission handled this. And you guys,
Right.
you came to a hearing in September.
September 9th, we were not allowed to speak, but we were attended.
Was that? Well,
That just seemed undemocratic to me. That
we'll get into that.
we were told the back and forth was messy. They wanted to avoid that.
And when you say the county wrote the guidelines for the appraisal, was that Planning and Zoning Commission?
Walter Bird
Guidelines?
produced a document.
After the fact, it wasn't
After
part of
the
the
fact.
meeting minutes.
After the October 4, he
We
went
didn't
out
see
and
it
produced a
until
document.
Ms. Cerruti's grammar request was.
We happened
We got
to
a
get it.
copy just last week of it,
Yeah.
so we didn't even know about that.
Though we have submitted a grandma for it, it's not been produced by the county to date.
So, but so it came from Walter Bird, probably in his capacity as the Planning and
Plan
Zoning.
zoning, I think he wrote that, and
Commission.
we never saw it until it came as one of the attachments on
Okay.
Ms. Cerruti's amendment or attachments.
And
So
I
we
would
don't
like
really
to-
have all the background on that.
And I would like to give Sean some credit. He made a document in September, wrote an email where he cited this document. And we never had the document. And I would say that, well, there's a misunderstanding. I don't think he was at the meeting when the county directed Snell and Williams or their other firm, whoever's representing them. I don't think he was at the meeting when he said, no, what we're using as our yardstick for the CUP and the conditions of the CUP was the October 4th, 2012 minutes. Now, I don't think Sean was there, but maybe somehow he dropped the ball, and he's thinking he's operating with this latitude over here, and we're like, we don't even have this document. And by the way, I think it was rightly viewed, and recently by Walter Bird himself. I think he just wrote us something here, he sent us something that pretty much negates the value of that document in terms of a appraisal process to address this issue as put forward by the county.
Significant progress. You mentioned that was initially one of the things that triggered that they would buy.
Yes.
They'd buy you out before they did significant
Construction.
Is that what it is?
Right, because they wanted time, they didn't want to pay for the land then, right? They wanted to make sure the project was going to go forward. We agreed to give them a couple of years to do that, but the promise was if before any significant construction activities, they would buy every parcel at the agreed upon price.
Right.
And what happened was they waited till the 2-year option timed out. We offered a free extension. They stopped talking to us.
They didn't even return a phone call.
And then so we wrote a letter saying, look, if you're not going to build it, fine. But if you do build it and you don't follow with this agreement, we're going to have an issue. So they were noticed before they got involved.
I guess what I'm wondering is if you had that on the front end and then you entered into this other agreement for the lease for the 2-year.
That was the agreement for the 2 years. That was after the October meeting. Our appeal was the county put the appeal on hold so we could negotiate. We reached an agreement on February 2nd, and we tied the land up for 2 years. That expired February. We had agreed upon price.
Right.
We did that on February. So February 2015 that expired, and shortly thereafter they started their construction work. But the commitment to buy the property. I mean, because we had a set price for that amount, it didn't go away.
Okay, all right. Answers my question. Bruce, anything?
I'm curious what you would feel constitutes a first cousin relationship.
All I know is I do not know your genealogy. I guess a first cousin is. I've just heard other people say that Rob Adams is your first cousin. Is that true or not true?
Not true.
He's a second cousin?
To me, a first cousin would be my dad or my mother is a brother or a sister to his dad or his mother.
Yeah, and we didn't make a big issue of this. I did say, as for somebody, so if you're not, you're a second cousin to, but he's the brother of Greg. To us, it's immaterial, right? I think there should have been disclosures, but you know what, that's all of the bridge.
It's
We're not even
significant
here.
enough for you to put it on your information.
Well, and I'll tell you why. The information we had to submit went to Greg Adams. And all of a sudden, the next day I called to Sean, oh yeah, we've got a copy of that. How'd you get a copy of our letter to the county attorney? You know, I'm like, well, and why when we do a grammar request does it get turned down? So I just felt uncomfortable in the fact that the person that I had to deal with was the brother of the developer. And and I found that out only through our own research, right? It wasn't like Greg said, hey, my brother's a developer for this company. And so I just thought that as a matter of course that should be disclosed.
There's a difference between pointing this out, Commissioner Adams, and making it a point of disclosure. I mean, this is our thing. We have to put it in the record. We have attorneys, we've talked to them. There are things we just have to put in the record, drop in the record, and we move on. It's not to take it personal, but we don't know. You have your contacts. If you would do a government, in my capacity over the years, I know exactly what we had to do. I mean, it's ridiculous. I'm not saying you should get up to the federal level in some of these issues, but I think for the benefit of the people that you proudly represent, and I understand in so many ways well represent, it would seem just the natural thing for us to point it out. And going forward, there are some things you can learn for going forward, but it's not going forward for us, for them to come here and hurry everybody up so they can meet their sacrosanct deadlines and give us the money they appraise for.
Yeah, I mean, even
It's like turn backwards. And I'm just saying, slow down and think about it. Don't let them drive this
the
in
chairman
that
of the
way.
planning commission stated on the meeting that just because they spend a bunch of money, that can't influence their decision. If I recall, Marcia, you mentioned that. Because they made the decision to keep spending money, and now they're arguing, oh, we spent all this money, so now you can't
That's
stop
the
us.
argument. You heard it today. We've spent a lot of money to stop. We'll go make the argument in district court, but for practical purposes, the building
Well,
permit is
that's
what it
beyond
is.
what my question was.
Okay.
I just want you to know that there
He's
is
not your first cousin.
There's not a first cousin relationship.
Okay, I appreciate
I
that.
understand what the disclosure requirements are. I have no financial interest in the project, therefore I don't need to disclose anything.
I might be mistaken, Commissioner Adams. My understanding of disclosures is maybe this is the time to look at this because small communities work a little bit differently than big cities sometimes. And we also now include family. So some of the disclosures that I'm aware of, or seem to recall.
Well, his as an FBI agent are probably much more
Is
significant.
you have family disclosure issues that would avoid things like this, right? And again, officially, we have never taken shots at anyone on here. We realize that you get paid a lot of money for all you do. Kidding. We realize that the sacrifice that you make is just critical to good government, and that's what we're asking for. We're asking for good government for us. This is basically the last shot before we have to dip into our pockets. And I think Mike's presentation, if I could just say this, has been very clear. He's cleared this up. We could have directed Ms. Marcia or anybody else to at least our side of things to look at. But they've already written it down. Their action is adverse to us. It's already a matter of record how they view this. Now for them, it's just a dollar amount. Don't be fooled. We're not trying to get crazy here. And if you came up with a plan that I could sign a document that we wouldn't do some, that was within this range or whatever the parameters are, we're good with that. We want you to have a great county. I'd like to live here. I like your county.
Are there any
We
other
better
questions?
see if Rebecca has any questions.
No.
Okay. All right. Thank you. Marcia?
When you're ready. Okay. You do solemnly swear that the evidence you shall give in this issue, pending between Northern Monticello Alliance and San Juan County Planning and Zoning, shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do so swear.
Thank you.
Commissioners, I actually was going to somewhat use my original statement to say the beginning of this again, which is we made our decision based on the information handed to us, presented to us, and not in an arbitrary and capricious way, and that it's noon. And that if you have any questions about how we did that, I'd be happy to answer. Listening to the presentation, I instead have written a few of the questions, if you will, and so I'd like to just address them and see if that basically reaches what you did. I'm just going to kind of go through these, and then maybe we can get specific if you need to. Real estate deals are not under the purview of planning and zoning. It's not unlike, it's just not up to us to determine rates, appraisals, purchase prices, or even purchase agreements. We can suggest to powers that be that they might like to work nicely with our neighbors and make some deals, but we cannot enforce a real estate proposition. I am not in specific knowledge of any appraisal document. Mr. Laws is nodding because I sort of question what that is. So that will have to be addressed separately. Let's see. We do not have in San Juan County a requirement of notification. In my last life, when I did planning and zoning somewhere else, there were specific requirements for notification for some things, like perhaps CUP or others, where you said there will be a specific hearing, a specific CUP discussion for this neighborhood. You must notify these neighbors. San Juan County does not have that in our zoning codes. Thus, the NMA was not specifically notified of these various meetings. The NMA points out some relocation maps. You will have to talk to sPower about those changes in the map. I take it to be design changes meant to address noise, sound, flicker. Perhaps the argument is that they did or did not get better. I don't know that engineering-wise. That was the map. There was talk about ice throw, and ice throw was definitely mentioned in the original hearings about wind farms. I fast forward to the hearing for the CUP when the words sound, flicker, and light mitigation were used. So was the sentence industry standards. And what happens there is NMA is correct. We do not have those standards in place for San Juan County. We were given, they said we didn't study, we didn't know them. That's true, we didn't. However, we were given a lot of material. Greg actually compiled some material for us that I actually did read, talking about standards and industry standards, and we passed along to the CUPs we issued, specifically this one at this time, saying you must meet industry standards for light, ice, sound, all of the things that we know protect our neighbors and friends. The engineers are the ones who will have to answer how they did that, and they did to our satisfaction at the meeting, because I keep wanting to come back to the meeting. They explained to us new towers for sound, or new engines for sound. They explained to us flicker mitigation, some of which was actually paying or preparing to pay for curtains and things. It's it may not be ideal, and neighbors can be, it can be a challenge to the neighbors, but what they were doing was meeting the requests of planning and zoning to say, we are designing the best way we can to answer those questions. That was our charge at this meeting, to say, from what we understand, yes, you are. They mentioned that they issued the building permit without knowing what standards were met for the CUP. There was a question put to Greg that said, Greg, did you ask when you issued the CUP, the building permit, if they met conditions of the CUP? Greg did not do that. It was still under Bruce Bunker, I believe, to issue that building permit. And by the time the signature came along, it's Greg's signature as Bruce had left. That needs to be clarified in-house for timing. We don't have that specific answer of what did Bruce ask. That's all I can put on that line. We did issue in our sentence at the meeting the idea that any conditions were passed on. So now we're at the October meeting, which updated, amended, and changed the original CUP in July. That amendment in October, issuing the CUP amendment, was any conditions put on any owners will carry on and carry through. And that's because it was explained to us by virtually all three of the various wind farms, but this one in particular, that the process is so-and-so will likely buy this from so-and-so. So what you've heard today about who bought from whom was part of our knowledge. It was explained that a developer does the first step, then the power company, and then the buyer does, and then it's exactly what you heard tonight of who owns what. We said, we don't care what your name is and who owns what. Take our conditions all the way through the development, no matter what your name is. The public hearing question, NMA, is correct. There was a piece of paper generated first in email form. It was sent to me and it said, we'd like the following questions addressed at your hearing. And this was for the September 9th hearing. We were told in fact it's in today's appeal letter too, that you may not contact anyone to do this. You may submit your answers to the appeal, but you may not contact us or the boards. It's in your hearing paperwork today. So I said to Greg, I would not forward the email, Greg, based on the idea that this is contact between parties that is not allowed. When I got to the meeting, they were physically handing out those questions, and that is correct. I asked that they not be handed out. In fact, I think I took it from one of the men and said, guys, this is not applicable to this evening. Backing up a step, what we're saying is, the reason we were there in the first place is because they filed a complaint, a challenge. They went through our county attorney and manager or whomever to ask these questions. It became a quasi-judicial or administrative hearing action, at which point we only address the person that's been challenged and say, answer this challenge. We said to sPower, the challenges submitted, in this case by Ms. Cerruti and NMA, the challenges are, and we have narrowed them with the help of our county attorney and Walter Burtis, they narrowed them to the two issues. Did they complete their work in a timely manner? And did they mitigate what we asked to be mitigated? So that becomes a administrative hearing. We stop the public and say, please come and please listen, but we are not going to ask for your input, much the same as you're doing today. You're asking for the challenge which had been written into a hearing to be answered by those that were challenged. We were instructed or informed not to take give and take because that's not answering the question, it's prolonging and changing the question. That's my answer to the discussion that I did take the questions off the table. It was, in fact, because they made those submissions that we did that. It's called a hearing at a public meeting as opposed to a public hearing, which you will recall we held public hearings way back when in the wind farm process. And we had lots of neighbors for all the different hearings of these wind farms telling us the good and the bad and the ugly. And that's the decisions that were made then. The decision made in September was to uphold our decision of CUP based on information given to us or answered by the owners, the challenge. I think that answers my notes that I took during the presentation. Do you have any questions?
I
Do
don't.
you, okay, I'm not sure exactly
Okay.
how really to get to
Okay.
this, but so you say that the planning and zoning is not in the business of being a go-between for developers and landowners,
Correct. Private land deals.
private land deals.
Right.
But they I don't know if they inserted themselves or they were invited to insert themselves in the mitigation
Who was?
part, the Planning and Zoning Commission, because I think they put as one of
The mitigation of the private land deal? No.
I believe that one of the conditions there stated that it would be that mitigate to the maximum extent possible or something the flicker and ice throw.
Flicker, light, sound were
Okay,
the
all right.
words used. Okay, go
Okay.
ahead.
I mean, that kind of puts you in an obligation to if that hasn't been mitigated, then that would be a condition of the use, isn't that
We can't tell them that mitigation is purchase of property.
right?
We can tell them that mitigation is necessary by virtue of mechanical, if you will, solutions. We can say, look, you have property owners who are going to be affected by this. How are you going to do it best? They answered with new towers, new
Right.
new energy.
I mean, we've already covered that this
Right,
is
right.
not standard day-to-day operation for the Planning and Zoning Commission. I know you're not experts on it. We could bring in
I'm going
experts
to
in,
be shortly.
and I think you know, hindsight's 20/20. I think we could have used some expertise from outside the area. You know, maybe some things to make this obviously.
Well, there's the old discussion of waiting it out, and you stop and you do moratoriums and you do,
No
hey,
question.
you know,
Right.
hey, we can't do anything till we know everything.
So I guess as you know, as I feel like as a commissioner, the number one obligation I owe is to property owners in the county. You know, citizens and people that own property, and which includes big property owners. Doesn't matter if they're you know, corporations or individuals, but you know, we have a real obligation to look out for the property owners, for that they don't get rolled over by either the government process or the corporate process or something in between. And as a Planning and Zoning Commission, I think that's the same. I think you share that.
We absolutely do, because the discussion is, in fact, how do you protect land surrounded by something? And that's the CUP process of saying this use is very different and not just allowed to be there, but if we allow it, how can we protect it? And the idea of the private land is not unlike the idea of covenants on our zoning codes for subdivision. The zoning code for subdivision is that we don't enforce covenants. The county can't do that. That's private land. We can read them and make sure it doesn't say, you know, you will bury your house in mud or something. I mean, if it says something silly, we can go, are you kidding? You know, but we can't enforce the covenants that say you will paint your house red, or you know, the things that you do in a subdivision. So it's a similar state to say these people have land they're working with the developers to figure out how they're going to mitigate. We say mitigate it as mechanically correctly as you possibly can, and if buying them out would work, that would be great, but that's between them, not us.
Just if planning and zoning says, I mean, we don't, but if we said you'll paint your house red, then there's got to be some enforcement to that, right?
Well, enforcement is an interesting issue because who says what you do? The building department does, the follow-up,
Well,
if you will,
I
the
guess
inspectors.
I guess that's why I'm saying if the planning and zoning commission could avoid putting any conditions, then they don't have to enforce that condition. But if they put a condition, then they are obligated to.
Okay,
to-
but we
to-
didn't put the condition on to buy the property.
No,
Okay, so I'm not sure what you're asking.
just the mitigation. I'm just coming back to that mitigation. I'm trying to wrap my head around this too. And then the other thing that, and again, I don't want to be critical at all.
No, I'm
board,
trying. I want to explain too.
But it seems like if you're going to have a hearing for the appellants, that the main thing you'd want to do is turn some time over to them and let them explain their whole thing. I know it's time consuming, but did they? I don't think they got
they
that.
had submitted their questions through the attorney's office, I believe, through Walter's office, and perhaps I don't honestly know what kicked the process into gear, except that we finally ended up with the process of let's do the hearing to find out what they're asking.
I guess it's I'm just wondering on that hearing. Do you think that was a fair hearing for? And maybe that's not a fair question either. But do you think it was a fair hearing to the appellants?
I do understand what you're asking because it comes from the NMA discussion of, hey, you didn't let us talk.
Yeah.
I believe it to have been a fair discussion because we wouldn't have had the talk, discussion, or presentation had they not submitted their questions. The process was ongoing. They'd been issued their CUP, then they'd been issued a building permit or whatever. The discussion was stopped or started, if you will, when the challengers came forward, when the appellants came forward and said, we have an issue with this. Once they did, it was condensed, if you will, into that hearing that said, answer these questions. And I believe we did. I believe that virtually everything that was brought up by NMA, even Ms. Cerruti earlier, although she got a little deeper into hers, but those are the questions that I knew I was asking at the hearing. I was asking, did you mitigate? Did you do this in a timely way without usurping or undermining, your deal with the owners? I believe that's why we sat there and had the challenged the owner answer that.
Okay. I don't know the legal terms for
I'm using
when
that.
you do a hearing that's just based on briefs. Is that you don't actually hear testimony, but that kind of is what seems like maybe that what this hearing was one where you don't hear testimony. And in my opinion, I think it would be one where the board would want to hear testimony.
I understand, and it was a discussion that planning and zoning had with, I think, Walter and Greg and I and the commission. It was at the commissioners' meeting, and we said, I'm pretty sure I said, so then each person will, it's like, no, this will be an answer period, basically. An answer, the hearing is to answer the charges. I keep pointing at sPower. sPower will answer the challenge. And that's how we were informed to make it happen.
Okay. Questions? Okay. Thanks, Marcia.
Thank you.
Do we need a break, or are we good to plow right into it? Okay.
Paul Shakespeare on behalf of sPower.
Well, I guess we do need to swear you in again. So.
We got some Bibles for you. Thank you.
We can go over there, yeah.
Yeah, get on the record, right?
Yes, is it just you?
I believe so this time.
Okay. All right. You do solemnly swear that the evidence you shall give in this issue, pending between Northern Monticello Alliance and San Juan County Planning and Zoning, shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Once again, express appreciation for the opportunity to be here today and for the time you're taking from your busy schedules, I'm sure, to hear these matters. A couple of things that I think we should talk about initially is housekeeping items. First of all, notice of appeal submitted by Northern Monticello Alliance was very limited. It was basically to discuss appeal of the decision about mitigation of liquor, light, and sound, and also this financial mitigation that they seem to want. They didn't mention a lot of the things that were talked about today, such as ice throw. They didn't mention the OCAS radar lighting control. They didn't mention anything that was brought up by the September 22nd letter from Curtin McConkey. They didn't bring up regulatory takings or a purported failure to exercise fiduciary duty. All of those issues, if they wanted to have you hear them today properly, should have been brought up in their notice of appeal. Those items are briefed in their appellate documents. Frankly, sPower was unaware that those issues were on appeal, and there's no reason for the commission today to take action on those items. And I think, so again, the question goes back to what was discussed at the September 9th meeting and the vote that was occurred on September 14th. And I think we can limit our discussion to that. We've provided a significant amount of briefing on the mitigation efforts that were undertaken in hopes of satisfying Northern Monticello Alliance's concerns, as well as the city of Monticello and other landowners. There have been mitigation efforts, and again, I brought these up at our prior hearing. I don't want to belabor that, and they're in the documents. If you have any questions about our mitigation efforts, certainly we're happy to answer those today. And based on what we've heard today from the Planning Commission and what the submissions have been, there's certainly substantial evidence to support the Planning Commission's decision that sufficient mitigation requirements were fulfilled. Today we've heard a lot about, well, they could have done this, and they could have done more, they could have done more. Well, as much as possible does not mean everything that is possible. It means what makes sense for the project, what makes sense, in a cost-benefit analysis, how do we reduce impacts, but also do it in a way that will allow the project to be profitable and have a long-term impact on the county, and to the benefit to the county. And that phrase is something that was coined or brought up by the Planning Commission. I think that they're in the best position to know what they meant by, as much mitigation as possible. They evaluated that. They found that our actions are in compliance with the Conditional Use Permit, and I think that there's substantial evidence for you to rely on their determination today. Their decision was not arbitrary and capricious. They took the complaints that were submitted by Northern Monticello Alliance very seriously. sPower came down for a hearing on the 9th, spent a significant amount of time with the Planning Commission to talk about what had been done. And so that's kind of the crux of the mitigation efforts that have taken place. It seems like the trickier part is this financial mitigation that you brought up. I certainly wasn't involved when the original conditional use permit was issued in October of 2012. But it's clear from the county's briefing that there's this document that references an appraisal process and things like that. The Planning Commission has gone on the record as saying that wasn't a condition of the conditional use permit. They weren't, as they said today, they didn't want to meddle in a private land transaction. They were going to leave that to NMA and the then owner of the project to work out. Part of those efforts certainly was an option agreement. Under that option agreement, Wasatch Wind agreed to pay $1,250 per acre as part of that deal. And then it also provided for another cost per acre. Crucial though, if you look in the binder that you have there before you, it's an option agreement. It's not a requirement to buy. There's nothing in that document that says whoever buys this project has to buy Northern Monticello Alliance's parcels. It just doesn't exist. There's nothing in that agreement that says that. I think if you go to tab 4, you'll see the complete option agreement. And it's titled an option agreement. It says, each owner hereby irrevocably grants, conveys, transfers, and assigns to Latigo Wind an exclusive option to purchase such owner's parcel on the terms and conditions herein provided. And then turning to the next page on paragraph 4. In the event that Latigo determines to exercise each option, so again, if they decide to exercise the option, this is what's going to happen. And then later in that paragraph, towards the end, that Latigo Wind shall retain the right at any time prior to the commencement of significant construction activities of the wind farm to terminate each option in this letter for any reason. So, and beyond that, this option agreement expired in 2 years. It expired in 2015. July of 2015, sPower starts construction at Latigo. And it was under no obligation to purchase the property. Nevertheless, sPower has been engaged in significant back and forth with NMA. We've gone through an appraisal process. We've had an appraiser involved. He's issued several appraisal reports. The binder I've just given you has a copy of the most recent appraisal report. It identifies the property being worth $2,900 per acre. We've actually offered them more than that. They've already been paid $1,250 per acre. We're offering them $3,200 an acre, and that's still not sufficient.
On top of the
On top of the $1,250. In other words, so we're over $4,000, well beyond, 150% beyond market value, according to an independent appraiser's report. And instead, we're met with this appeal and these complaints about whether or not we comply with the conditional use permit. And I appreciate concerns about notice and whatnot, but frankly, they were the ones that appealed the original conditional use permit in July of 2012. That's why the conditional use permit was issued in October. It was because they were involved. They participated in this process, and that's kind of the way things have come out. And then also in this binder I provide you is some of the back and forth between Mr. McBride and Mr. Bingham and members of NMA about the offers to purchase the land. And all we've seen in return is a comparables analysis. We haven't seen an appraiser's report. We haven't seen anything else that would substantiate the $9,000 that they're demanding per acre. So we're willing to engage, but we're also not going to be paying out holdouts because they think they can threaten us with these sorts of appeals. So on top, there's mention in NMA's appellate meeting that they want to, have 5 parcel residential lots there. That's great if they'd like to do that. But the fact of the matter is they have done nothing to bring that to fruition. There are some parcels that have been subdivided, but they're certainly not 5-acre parcels. What will they do for water up there? Are they going to be able to share one well or not? They don't have any valid water rights at this time, as reflected in the documents from the state engineer's office in this binder. There's a lot of other hurdles that they haven't dealt with at all on this property. I appreciate they own it, but at the same time, we need to be realistic about the value of that property. So, finally, I don't bring up zoning estoppel to be threatening or anything like that. Again, my perspective is a fairness issue. We've been participating in the process with the county. We've been performing mitigation efforts, significant mitigation efforts, all along working with the county and trying to make this work in the area. And now, the last minute when we're getting there, we're starting construction, we're having the transformer delivered and everything else, we have these folks that are bringing up challenges that could have been and should have been addressed long ago. And I think with that, unless they have any other questions, I think we'll be done.
questions?
Yeah, it looks to me like in here that there were 9 individuals or 9 parcels
That's correct.
that were, and these gentlemen indicated that they were representing 17 people. Is there 17 parcels or 9 parcels, or is there 9 parcels with 17 people have an interest in it?
I'll defer to them, but I think there's 9 parcels with
Okay.
17 different owners involved in some way or another.
Okay.
I know one of the property owners you've made a financial settlement with, kind of significant one and kind of a public one with the Four Corner School. Does that, in your mind, does that have any bearing on what you do with other property owners? Does that set a market value or a precedent in any way?
I am not as familiar with the Four Corner School.
I'm not terribly familiar
Yeah.
either. Just
But I would presume that was in a kind of a similar process. It was a negotiation based on fair market analyses of the property value.
It wasn't a purchase, Mr. Lyman.
Yeah.
It was an agreement
no,
for.
I didn't say it was a
Yeah,
purchase.
okay,
I said it was a
okay.
financial settlement.
Yeah, sorry.
So, but it may for some people set that expectation. But again, if there is some sort of CUP condition regarding financial mitigation, it would be through this appraisal process that's been referenced but was not adopted. And that's what we've tried to do, and certainly in good faith trying to work this out.
Rebecca, do you have anything? Okay.
Sorry, I just want to double check my notes.
I can speak to the Discovery School.
Can we swear 'em
if
in?
you'd like to have a little more information about that.
Yeah, we could swear him in if we wanted to. Give me just 1 second. Yeah, I've taken a couple of notes. I think that when you say, I think attorneys call it litigation language when you say everything possible or something like that. That you end up leaving things unclear. There's not a clear, bright line there. So
Right, there's a little bit of language is often imprecise.
Yeah.
I'm trying to determine what was meant by that. I think the best evidence for you today is what the Planning Commission said and then subsequently evaluated in September of this year.
all right, thanks.
I went down to see if he's
Oh,
Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
thanks.
As to the agreement that was reached with the Discovery School, where we sPower as a company. We covered it. Yeah. sPower as a company where we have communities that we have a significant presence. We very typically sponsor local events, schools, things like that. For example, we have a significant portfolio of solar assets in Lancaster, California. We've done a number of sponsorships down there with local schools, different business programs and things like that. So when we started discussing with the Discovery School, it was much broader than just the mitigation. So the mitigation was a component to it, but the overall number that I think is out there in the public documents was a broader agreement because the school kind of shares our values and we wanted to make a contribution to the local community. And so I wouldn't want you to think that was like just, hey, we're impacting them with 20 minutes of flicker a year or something like that, and so we pay them, I think the number was $250,000. It was a much broader agreement than that. Oh yeah, so sPower has never had any rights in this project until June of this year. We were not involved at all with this project. None of the management team, myself included, was involved with this project prior to June of 2012, other than a short time at Redco when we talked with Wasatch Wind about potentially partnering because we had another wind project in the area. But sPower had not been involved in this project until June of this year. And so, a lot of the allegations about family relationships and those sorts of things, we just weren't involved in any of this process, the initial permit or the building permit or anything. We just were not.
Okay. I don't know if this is a question for Paul or for you, either one, but I guess I just want to say, for what it's worth, which in this context is really virtually nothing, but we love to see companies come in and do big projects and spend a lot of money, and you guys certainly have, and that's good to see. From my perspective, the concerns seem reasonable and legitimate, and I hope that at some point that gets resolved. And I agree with Marcia that it's not the county's position to interfere in all of that. But I guess I am interested from the Planning and Zoning Commissions how far we were involved in that, and did we do our due diligence. So anyway, I guess just on the record that we appreciate you guys recognize these concerns, and again, these things that we don't deal with very often, we recognize that they can have huge impacts. When you talk about somebody's property, you're talking about their soul, and I understand that too. So just
we share your sentiment. We understand these are sensitive issues. We've tried to reach out. I think there's been sometimes a contentious, sometimes a productive discussion between the parties. I think Dan would recognize that. And so what we established, again, the enforcement of a private land agreement, we don't believe is within the purview of this review. But that said, when we began talking with the Northern Monticello Alliance, we tried to look at this and say, what's the best way to determine the value of this property? So we went out and got an appraisal done. The first appraisal looked at the whole 80 acres of the block, came back like 1,000 acre, and they were trying to sell us that as a block, so we kind of looked at it that way. They disputed that, so we said, okay, fine, we'll go back and do a new appraisal. We'll take the most valuable property in the group, which is one that had road access and a well on it, had an expired water right, but still had a well, which is valuable. And we had an appraisal done on that property, and that's what came back at $2,900 an acre. And so we felt like we were making a more than honest effort to get it resolved through a process that's not just picking numbers out of the air.
Do you know how big that parcel was by chance?
It's a 10-acre parcel.
Anything?
No.
Okay. Thanks.
No.
Thank you.
All right. If you need a break, we're glad to take a few minutes. But
Whatever you want.
we're good to plow ahead, I believe.
Commissioner, you good?
Just don't want to get anyone fatigued. And
We'll try to make it, of course, real quick, and Mike will have a few things to say. Let me run a couple things by. It's kind of how I started this meeting. I just wanted to look at it practically speaking. Practically speaking, we still have a problem. It was recognized by Wasatch Wind that they couldn't handle it but to mitigate with us and purchase our property. They acknowledged that. If they can come up, you don't have, here's the whole point is, that's why you do building permits, in my understanding, to what limited understanding of building permits I have, but I have some. And one of the things about building permits is it's there so you can pull it for all kinds of reasons. You don't have to direct them what to do. I guarantee you, any one of them is smart enough to figure out in about 30 seconds what the next step is. Don't have to tell them. We've never asked for that to happen. We wouldn't expect you to do it. But that's what big boys and girls do. You don't have the mitigation, as we demonstrated you don't have. You're in not only forget the money, forget our rights. What about your son going out hunting down the road one night? He's going to go get himself a coyote up that road, and that blade spinning. By the way, the tip blades on those things are going at 204 miles an hour. And they'll chuck a 200-pound chunk of ice. Car, person, you want that risk. As far as this talk about keeping it limited, I don't know how they compiled the order for today, but to speak to the attorney's comments, I sent an email document to Kendall. Mike put one together in my name. We sent that to the county. I sent it. I thought Kendall was a point of contact. Kendall Laws, your county attorney, was a point of contact for that. Mike put one together. When we talk about safety issues, how can you not talk about it? If you want to be legalistic about it, not really care that much, go that deep, and say maybe somebody could come up with an argument, as he just tried to do, and limit what this is about. The developers understood it. You all understood it. Now why do you fade at the end? Have them come to the table. if there's some kind of thing that they want to put forward where we don't do some, pay us $2 million. We're not jokers. We didn't say ever, oh, we had a golf course planned here. Oh, we're going to put a motel here. And you owe us earnings from a motel. We've never done that. I would never do that. It's just not part of the plan. I think just being reasonable here will solve this problem. And will go away. Other problems, I don't know. I was thinking maybe we'll just have to talk to Cerruti and see if she wants to put up some wind turbines on our property. I don't know. But I mean, there should be some common sense approach here, which I think they recognized. Bravo for the attempt as a corporation to not spend a dime they don't need to make. You know, maybe we should put them in government. They could straighten out some of our government issues. I know at the federal level there's plenty of them. But anyway, so be clear. We gave several documents that include those issues. Maybe you didn't see them. Let's see. Yeah, hold on a second. You do evaluate as planning. You do evaluate planning and zoning work. It is up to you. It's your job. That's what you're here for. You can say, well, we're sending it back to you and say whatever you will. But it is an oversight responsibility. You do have a latitude. Heavens, we've seen all kinds of latitude given to them in every case, whether it's talking about signing a piece of paper. And oh, by the way, the signature is a point where it breaks down. Greg can sign it because somebody else thought it was good, but that's Greg's signature. And by any lawyer standard, by any reasonable standard, that signature should stand on itself. Marcy made a point about that, and I understand it. But you still have, that's where we come to, okay, at this point in time, you sign here because you're authorized to sign. You can't really ignore those kind of things. As, you know, you can minimize them, you can explain them, but legally, it's got to make sense. I'm glad that they mentioned that for the first time ever, even above a September letter that Sean indicated, as I recall it, that money that they paid us for the 2-year was basically rent, kept keeping us off from our property and doing anything to our property. We're now in year 3 on that. That we brought this up at the last minute simply is not the case. None of this is the last minute. This is very important to us, consequentially important to us. This is what if they honor the original contract, it's point 0. If they honor the contract, it's 0.005289, something along that order of an issue. So the idea that somehow this is all last minute and it's just not there, that's just what you do to avoid what's coming in could come in the next step.
Specifically the last minute issue, the day after the option expired, we wrote a letter to Wasatch Wind, Intermountain, Latigo project saying, hey, you know, great, if you're not going to do the project, fine, let it expire. If you are going to do the project, we will extend it, and if you decide to build without purchasing our property, we're going to be in a bad situation, and we'll have to resort to whatever thing we have to, including litigation. So they knew that from the very beginning, and we've been timely as possible at every time since.
There's a lot of issues that between the two property interests up there that probably don't necessarily relate directly to.
Right. I'll try to
the
just
hearing.
address the planning and zoning issues then.
Yeah.
Saying the Planning Commission, I think was the quote, doesn't regulate private land. The Planning and Zoning Commission has a huge impact on the impact and valuation of private lands. Allowing the tallest structure buildings in Utah, these are taller than the highest building in Salt Lake, these wind turbines. Allowing 12 of those to be in 1,000 feet of our land and 55 decibel sound over 17 acres of it, even higher over portions, is clearly decimating the value of our properties for our intended use. So whether they affirmatively do so or not, they certainly have a huge impact on private land.
Let me say one example of that decimation. If I go into the bank and I tell them what I want to do and they understand where I'm going to put that property, it's going to be a hard sell to get the loan that I want
It's
to
going
do.
to get a mortgage on it if we try. Ms. Sandoval will call it a quasi-judicial hearing, yet only one side is allowed to speak, and we did submit questions, and those were not submitted and not allowed for us to present questions. So we couldn't even say, hey, these are questions you ought to consider. And we said, look, could you consider these questions? We didn't say you need to ask these questions, but would you consider asking these questions? So you can't have a quasi-judicial hearing and only hear one side. And we weren't allowed to prevent any kind of rebuttal information. And the presentation, frankly, was a rambling, hand-waving presentation with very little detail. The same as today. They haven't addressed specifically the fact they moved these towers so much closer to our property and how that's impacted ice throw and noise. they've completely ignored all the facts that have to do with mitigation. And clearly they cannot mitigate to within standards. The Planning Commission didn't do sufficient due diligence. In the last meeting, one of the commissioners thought it was a 90-foot high tower, not a 450-something foot high tower. We were told the towers didn't surround our property. Look at the map. How can you say they didn't surround our property? There was a real lack of understanding of that and a real lack of understanding of what appropriate standards would be, like the ones in Massachusetts, the ones in Oregon, or any other state. You're not going to find a 55 decibel standard for neighboring parcels. So a lot of general platitude, no specifics. In terms of sPower, it didn't say mitigation is only required if it allows the project to be profitable. Clearly, they can't mitigate by putting the towers closer to us. They moved Tower 9, which was on the far east end of the project, closer to the school, right next to our property. So yeah, they may have mitigated some other property owner, but they put it right next to our property. And so that is not mitigating us. Our appeal spoke specifically of safety. It's right there in there, and in self-imposed conditions. And their willingness to enter into a purchase agreement is a self-imposed condition. They may have let the 2-year time period expire. That doesn't mean they don't need to still buy the property in order to build. I mean, that was what was told to the Planning Commission. They would buy this property, and that's why the CUP was issued. And that's the enforcement that we're looking for. The saying it's not 5-acre lots. There are 4 or 5-acre lots already. My family's trust has 10 acres split across the middle. We have a plan for access road down the middle, so it clearly will be 2 5-acre lots. One of Dan's land also will have to be split. We were in the process of doing this. His father-in-law spent over $20,000 on a well, and then of course we entered this agreement where we can't do anything for 2 years. So yes, our well permit's expired, but it can easily be renewed. So this argument that, the well's not, water rights aren't even valid, that's specifically because we had to put all of our development work on hold. We didn't go through with the road down the middle because we got into this thing with the wind farm. So that's just ridiculous kind of comments. The fact is, I'm a supporter of wind energy, but I want to see ethical development, and I want to see well-placed projects. I had a large project in Canada that was submarine because one company wanted to put a project right next to a city, creating a whole firestorm of anti-wind. And in this case, the project could have been further north, but somebody else had those land rights, so they went and pushed it right down around our property and right next to the city. So all we have to do is, there was an agreement made to buy the property that's not within the purview, but the planning and zoning either says you have to mitigate, and the mitigation hasn't been performed. They either need to move those towers away from our property, and to get down to 40 decibels according to their own noise study, they would need to be 2,800 feet away. So if they can't do that kind of mitigation, then somehow they have to do a financial mitigation. That's what they proposed, that's what we agreed to, and then they're coming back and saying, no, we don't want to pay that much. We don't think it's worth that much.
I'm happy to hear if they've got another proposal to that. I'd like to hear it. I've made several, including land swaps. There are all kinds of opportunities, and I've
That's outside the scope, though, right? Yeah. Is there anything else on questions that you have?
I don't believe so.
Anyway, we appreciate
Thank you for your time. Appreciate it. It's a long day.
Appreciate you coming down, and so we will get a response in writing and get back to all the parties involved. Thank you for your time today. Thanks, Marcia.
Thank you.